This is Justice Brett Kavanaugh, and he wrote the opinion for the court for a case called Jones v. Mississippi, which was decided by the U.S. Supreme Court in 2021. This was a 6-3 decision, and it has to do with juveniles who commit a homicide and are sentenced to life in prison without the possibility of parole. Let me take you through this case. We have a juvenile, Brett Jones, who was 15 when he took his grandfather's life via stabbing. He went through a trial and the jury came back, found him guilty. He was sentenced to life without the possibility of parole, which was an option for juveniles in this jurisdiction. He appealed his sentencing, claiming that under different cases that had been previously delivered by the U.S. Supreme Court, he should not have been given this particular sentence unless he had been deemed incorrigible, meaning there was no chance at all for any kind of recovery or any kind of rehabilitation. The U.S. Supreme Court had already sent down opinions regarding taking off capital punishment off the table for juvenile offenders, and also set out in the Miller case a 5-factor test when we're talking about what sentence is appropriate for a juvenile sentence. Following the Miller case came the Montgomery case, and this case set out that juveniles could be sentenced to life without the possibility of parole, but those were very rare situations. So this case went all the way up to the U.S. Supreme Court, and Justice Kavanaugh delivered the opinion for the court. And he said that you do not have to find that a juvenile is incorrigible or completely not able to be rehabilitated in order to be sentenced to life without the possibility of parole. That was not required. There was some discussion on whether or not this rule was substantive or if it was procedural. And in this case, Justice Kavanaugh said this is one of many factors that need to be considered when putting into place a particular sentence for a juvenile offender. In this case, he held that this particular sentence did not violate the Eighth Amendment right against cruel and unusual punishment, and that this sentence was appropriate given the situation. Now, this was, again, a 6-3 decision, and we've got 3 justices, Justice Breyer, Justice Kagan, and Justice Sotomayor, that dissented in this particular case. Justice Sotomayor went on to specifically say she felt that the Miller factor test was really coming into question, and the holding in that case was not being properly applied here. But there you have it. When it comes to juvenile offenders, when they're given life without the possibility of parole, depending on the circumstances in the situation, they do not have to be found permanently incorrigible before the sentence is given.